Bosasa donation being heard in the High Court in Pretoria today and tomorrow. In her report, the Public Protector Mkhwebane found that the President deliberately misled Parliament when he failed to divulge the details of the donations his ANC presidential campaign received. In particular, a payment from Bosasa. The late CEO of Bosasa, Gavin Watson, donated 500,000 rand to Ramaphosa's 2017 campaign. Mkhwebane concluded that there was merit to allegations of money laundering and found that Ramaphosa had violated the Executive Code of Ethics and may have exposed himself to a conflict of interest in receiving certain donation. The President's lawyers have criticised Mkhwebane's investigation as unlawful and malicious, adding that it was driven mostly by a reckless determination to malign the President. Sipho Stirman is there, but let's go live to the proceedings.
She interviewed lots and lots of people. We list them all on pages 33 and 34 of our heads of argument. But there was no evidence of money laundering at all. Nothing whatsoever. And then when she turns to an evaluation of that evidence, she suggests that there might be money laundering involved. But the extraordinary thing is that she doesn't realize what money laundering is. She doesn't realize that money laundering is an offence under Section 4 of the Prevention of Organised Crime Act, and that the essence of money laundering is the concealment of the proceeds of crime. In other words, if one were to investigate whether there is any money laundering involved in this case, one would firstly go to Section 4 of POCA to read the definition of money laundering. And then you would go to the facts, because you would then have to look principally for two things. Firstly, did this money constitute the proceeds of crime? That's the first inquiry. And then the second inquiry is, did anybody try to conceal that origin of the money? That is how one investigates the presence or otherwise of money laundering. The public protector, with respect, did not even realize that these are the questions to be asked. She did not realize that POCA is the act to look at. She looked at the Corruption Act, and she quoted at length from the Corruption Act. And then she says, we quote her on page 34 of our heads of argument, she says, my investigation into the issue to possible money laundering is premised on the above legislation, that's the Corruption Act, which has nothing to do with money laundering, is premised on the above legislation dealing with corruption and applies not only to private individuals who offer bribes, but also to private individuals who accept bribes. And not only does she refer to the wrong legislation, but she doesn't engage in the first step of a money laundering inquiry, and that is whether the money involved constitutes the proceeds of crime. The question is never asked, and therefore never answered. So, the public protector, with respect, embarked on an irrational inquiry because she does not understand what money laundering means, and then irrationally concluded that there is ground for suspicion of money laundering, when in fact there was absolutely none. And let me just emphasize this, because our learned friends for the public protector do not seem to understand our submission. We don't contend that it has been proved that there is no money laundering. Nobody has done a proper investigation to see whether there was any. But what we submit is that the public protector's finding that there is reason for suspicion of money laundering is unfounded, because there is absolutely no reason for suspicion of money laundering. In other words, there is a complete absence of evidence of money laundering. It's important that we make that point. We have never gone further than that. We have also not investigated this transaction. We know nothing about Mr. Watson and whether he's been involved in money laundering. He may well have been. So we don't make the assertion that nobody has been involved in money laundering. The assertion we do make is that there is not a smidgen of evidence of money laundering, particularly money laundering on the part of the President, and that the Public Protector's finding that there is ground for suspicion of money laundering is irrational, unfounded, and again speaks of a reckless determination to make adverse findings against the President, even in the absence of any ground for it whatsoever. And it is in that context that we refer to the evidence of the Financial Intelligence Center, because they filed an affidavit, and in that affidavit they say, after they had rendered their report to the Public Protector, they interviewed the Public Protector's representative, not the Public Protector herself, but her representative, because they were anxious to make sure that she correctly understood their conclusions. And we quote them on page 35 of our heads of argument, and I would like to go there. It's paragraph 83. 83, yeah. I'd like to go there because our learned friends have been very critical of our reliance on the evidence of the FIC in this case. We say the Public Protector also ignored the evidence of the Financial Intelligence Center. Its deponent, Ms. Kanyile, says that its analyst, Mr. Miller, who analyzed all the CR17 bank accounts, called a meeting with the Public Protector to ensure she correctly understood his analysis. They met on 10 April 2019. The Public Protector was represented by Mr. Rodney Mataboge. He specifically asked the FIC representative whether they had found any evidence of money laundering. Mr. Miller informed him that he could find no indication of money laundering, as he could not say whether any of the money constituted the proceeds of crime. He added that the amount of 500,000 rand received from Mr. Watson came from sources that appeared to be lawful. There was thus no suggestion of money laundering. So the point we make here is the point confirmed by the fact, not that the absence of money laundering has been proven, but simply that there is absolutely no evidence of money laundering, and the fact confirmed that. Now, our learned friends stridently criticize us in their heads of argument. I won't ask you to go there, but in their heads of argument, in paragraphs 107 through to 110, suggest that we disingenuously relied on the FIC as proof of the absence of money laundering, because they say in the very next paragraph of the affidavit, the FIC says, but you must understand, I did not do a comprehensive investigation into money laundering. But all that means is that the absence of money laundering has not been proven. We have never contended that it has. Nobody has done a full investigation into the question of money laundering. What we cited the FIC for, and what they expressly confirmed, is that they found no evidence of money laundering. And on this one instance, the one transaction which triggered the inquiry, i.e. the Watson donation, they say the money donated appeared to be derived from a lawful source. So we again have a finding by the Public Protector of a suspicion of money laundering, which is an irrational finding, an inexplicable finding, a finding, again, suggestion of a reckless determination to make a finding against the President. We submit, in the third place, that the Public Protector, in any event, committed a fatal procedural irregularity by her failure to afford the President an opportunity to make representations on a variety of issues. We list them at page 36 of our heads of argument. They are the information the public protector had received from it's paragraph 84. The matters on which she never afforded him a hearing was the information she'd obtained from the FIC, the CR17 emails which had been illegally leaked to the public protector, and the third was the remedial orders that she proposed to make. And let me say, I will emphasize the remedial orders because the other two issues, there may be a debate about the other two issues, whether they fall within the scope of matters which ought to be disclosed to the respond to the person being investigated. But when it comes to the remedial orders, we submit that there cannot be any debate that the remedial orders had very direct adverse impact on the press freedom. And the fundamental principle of law is that you do not issue orders of that kind against anybody without affording them an opportunity to be heard. I will deal with the three fundamental grounds or three manifestations of the Audi principle, which is really the same thing. But let me just start off, because the public protector says, we heard you on the merits. You were given an opportunity to defend yourself on the merits. We were not obliged to afford you a hearing on remedy. That's like saying in a criminal case that you will give the accused an opportunity to defend himself on the merits of the case, on the question of guilt. But on the question of sentence, he's not entitled to be heard and therefore must suffer any sentence without a hearing. It is an absurd suggestion that so fundamental a part of the adverse impact of her decision need not be the subject of a fair hearing. And there are three grounds on which a fair hearing is required. We deal with them from paragraph 85 of our heads of argument. The first is section 79A of the Public Protector Act. The Public Protector interprets this section to mean that she only needs to afford a hearing to somebody who's been implicated by her investigation on the merits of the accusations against him or her. She denies that it also requires her to afford a hearing on her proposed orders that she proposes to make. Now, if I may just read the section which we quote. It says, if it appears to the public protector during the course of an investigation, and I would then put in a 1. It appears to the public protector, 1, that any person is being implicated in the matter being investigated and that such implication may be to the detriment of that person. Or 2, that an adverse finding pertaining to that person may result. In other words, there are 2 triggers for the procedure that follows. The public protector shall afford such person an opportunity to respond in connection therewith in any manner that may be expedient in the circumstances. We make the point that there are 2 triggers, that someone is implicated or that an adverse finding pertaining to that person may result. Now, the remedial orders are classically an adverse finding pertaining to that person may result. And therefore we submit that not only the proposed finding on the merits, but also the proposed remedial order ought to be the subject. We submit, by the way, that not only the President ought to have been heard, but all those other people against whom the orders were made, the Speaker and the NDPP and the Commissioner of Police, all of them find themselves the subject of, or the target of orders out of the blue. And you know, and you will hear more of how much difficulty that has caused. Just illustrates how important it is that these orders also be put to the people against whom they are made for their input before they are made. But even if we're wrong under section 7(9), there is the common law principle which we cite in paragraph 85.4, where the SCA described the Audi principle in Trove. And this description, as we say in the following paragraph, has been endorsed by the Constitutional Court in 2 subsequent cases. So this is not simply old common law, it's also contemporary common law under the Constitution. That is that the maximum of Audi alteram partem expresses a principle of natural justice which is part of our law. The classic formulations of the principle state that when a statute empowers a public official or body to give a decision prejudicially affecting an individual in his liberty or property or existing rights, the latter has a right to be heard before a decision is taken, unless the statute expressly or by implication indicates the contrary. Well, this is an a fortiori case. The last is the requirement of constitutional rationality, which we identify in paragraph 85.6. And that is that even under the rule of law, even when paja is not applicable, and only the rule of law governs the decision, there is still a requirement of procedural rationality. And for all the reasons we have mentioned, the rationality requires that before you issue remedial orders of the kind that the public protector made in this case, that the targets of those orders be afforded an opportunity to be heard before they are made. Precisely because that is what rationality requires, and that is illustrated by this case where those orders have caused great consternation. There is then a separate attack on the orders themselves, on the competence of the orders themselves, and those attacks are also made by the Speaker and the NDPP. We simply align ourselves with their attacks, and I won't separately address them. In conclusion, on the President's case, before I get to Honourable Mkhwebane, there is a question of costs, and we do submit with respect that this is an occasion where the court ought to express its displeasure with the conduct of the public protector by making an order of attorney and client costs. We emphasize that in this case we're not seeking an order for costs against the public protector personally, but we are seeking a punitive order for costs in recognition of the public protector's reckless conduct in this case. Reckless in an apparent determination to make adverse findings against the President. Reckless without even explaining herself, without making any attempt to explain herself. Reckless in apparent disregard of the damage she does to people who don't deserve to be damaged in the way that she has deliberately done. So we submit with respect that a punitive order for costs is justified. I may turn then to the case of Mkhwebane. Just emphasize the limited scope of Mkhwebane's application. And that is that it firstly says that it makes its application conditionally. It is only if this court should find that the executive code does not require the disclosure of campaign donations of the kind made to CR17 that they make their application at all. Now, which means that if the court does not find it necessary to make such a finding, in other words, if the court does not get to the inquiry whether the executive code requires disclosure of campaign donations of this kind, then Mkhwebane's application is stillborn, then it doesn't take off at all. And we submit with respect that it is indeed unnecessary for this court to reach a finding on the question whether the executive code requires disclosure. We advanced two reasons for that submission in our heads of argument. It occurs to us later that we completely overlooked a third, because there are really three grounds. And the first is, let me just list them and then deal with them. The first is that the Public Protector's investigation of CR17 was unlawful altogether. My learned friend, Mr. Mkhwebane, will address that issue. But if you were to find that her
All right, we're coming out of the process. We just lost connection, but as you've just seen, Advocate Wim Trengove, Senior Counsel, trying to make arguments for his client, President Cyril Ramaphosa, there, and saying that the evidence that they have gotten was that there was a complete absence of evidence of money laundering, and that the decisions of the Public Protector, they found once again, were irrational, unfounded, and reckless. And this is boosted by information coming from the Financial Intelligence Center, which also says that there was no indication of money laundering and that the money came from sources that appear to be lawful. We're going to leave that for now and go back to